All right. Good afternoon, everyone. Thank you for joining us to our Environmental Law Section 101 series. Today's program is Navigating CERCLA Liability Risks in Real Estate Transactions with Kimberly Bick and Heather Dadashi, both with Bick Law, LLP. Our 101 series is put on by both the Environmental Law section of the California Lawyers Association. My name is Miles Hogan, and I'm the chair of the Environmental Law section this year. It's also put on by the California New Lawyers section, which represents all lawyers in their first 8 years of practice. Next slide. So there's many ways in which you can get involved in both the environmental law section and the new lawyers section. There's some examples on the slide here in front of you. Highly encourage you to sign up for other webinars that we're putting on this year, as well as our mentorship program. Applications will be opening up in the fall. Next slide. And then one of our signature events every year is the Environmental Law Conference at Yosemite. This year it'll be held October 16th to the 19th at the Tenaya Lodge, just outside of Yosemite National Park. Registration will open next Tuesday, August 12th. So be sure to check out the website and sign up and attend. Next slide. So we're here as part of our annual Introduction to Environmental Law 101 series. On July 23rd, we had our first program, Navigating Proceedings Before the California Public Utilities Commission. That recording is now available on our website, as well as the materials. And then our next program after today will be Fahrenheit 101, California Air Quality and Greenhouse Gas Emissions Laws. That'll be held on August 21st. And then we will have a pre-Yosemite Conference networking tips and tricks session in late September or early October, leading up to the Yosemite Conference. And here's the website for previous 101 sessions. We have several years going back now, lots of different topics for you to check out. Next slide. And please feel free to submit audience questions using the Q&A feature. You could submit questions throughout the program, and then our speakers will be addressing them at the end of the program. And if we run out of time to address all of your questions, please include your email in your question, and the speakers will attempt to get you the answer after the program. I will note that this PowerPoint will be shared with all attendees after the session is completed within a few days. And then the recording will be posted on that website at a later date. Next slide. Next slide. And without further ado, our two speakers today are Kim Bick, a partner with Bick Law, LLP. She's the founding and co-managing partner of the firm. She has extensive experience representing major aerospace, manufacturing, land use, biotech, and real estate companies in environmental litigation, regulatory compliance, enforcement, and corporate transactional work involving environmental issues. She regularly provides environmental counseling to corporations pertaining to regulations and business operations. She has unique subject matter training in contaminated sediment cleanup from Texas A&M. And she's also an advisor of the environmental law section and a former chair of the section. Heather Dadashi is an associate with Bick Law LLP, and she works closely with the firm's other lawyers to advise corporate and municipal clients on complex environmental law matters, including litigation, regulatory compliance, and enforcement. Thank you both so much for volunteering your time. With that, I'll hand it over to our speakers.
Hello, thank you for joining us today, and thanks to CLA for having us conduct this 101 summer webinar on navigating CERCLA liability risks in real estate transactions. My name is Heather Dadashi, as Miles mentioned, from the law firm Bick Law, and I'll get right into the learning objectives for today. So in this program, you will learn the basics of CERCLA liability, explore a real-world case study to understand the legal and practical implications of contamination discovery on property transactions, develop techniques to investigate and assess potential property contamination, learn how to respond effectively upon discovering contamination, and lastly, analyze options for allocating responsibility given CERCLA's joint and several liability scheme. Next slide. So for our agenda today, we will start with a brief primer on CERCLA liability and available defenses to just ground ourselves in the legal framework. And from there, we'll dive into a case study involving the discovery of contamination during a property sale. In the context of that case study, we'll explore how environmental due diligence can reveal historical contamination, and we'll walk through key strategies for managing risk, both through purchase agreement negotiations and through post-discovery response measures. We'll also discuss how to identify other potentially responsible parties, available insurance resources, and how brownfields and voluntary cleanup programs can play a role in property redevelopment. Next slide. In the 1980s, laws were passed that required identifying, investigating, and cleaning up contaminated sites. These laws impose potential liability on property owners, lessors, lessees, and others involved in managing or purchasing contaminated properties. Most contaminated site cleanups in California are governed by the following laws. At the federal level, there's the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA, which is regulated by the U.S. Environmental Protection Agency, or EPA. There's also the Resource Conservation Recovery Act, or RCRA, which is also regulated by EPA, as well as the Department of Toxic Substances Control, or DTSC, in California. At the state level, there's the Hazardous Substances Account Act, which is regulated by DTSC, state and regional water boards, and Cal EPA. There's also the Hazardous Waste Control Law, which is regulated by DTSC and Cal EPA. Liability under these laws is far-reaching. A person could be required to pay for all or part of a cleanup cost even if they didn't cause the contamination on their property. And a person can be liable for cleanup if they buy or lease property knowing it's contaminated, or fail to conduct adequate due diligence before buying or leasing the property. In addition to hazardous waste laws, there's also real estate disclosure laws. For example, the California Health and Safety Code requires owners of non-residential property to provide written notice to buyers, lessees, or renters if they know or reasonably believe a hazardous substance has been released on or beneath the property before its sale, lease, or rental. Next slide. Different classes of individuals are liable under these laws, which include, first, current site owners or operators, second, a person who owned or operated the site at the time of disposal or release of a hazardous substance, third, a person who arranged for a hazardous substance to be sent to or disposed of at the site, and lastly, a person who accepts hazardous substances for transport to the site and selects the site. Liability is strict, joint, and several. Strict liability means that liability may be assigned regardless of who's at fault for the release. And joint and several liability means that each potentially responsible party can be required to pay for all or part of the cleanup costs and environmental damages resulting from a release. If you conduct a cleanup, you may seek reimbursement from liable parties, including prior site owners and operators, through a contribution or cost recovery claim under federal and state law or through a common law action. Lenders who foreclose on contaminated property are exempt from liability if they attempt to divest themselves at the earliest practicable commercially reasonable time and did not participate in management of the property before foreclosure. And this lender exemption will be discussed in more detail later. Lenders typically require a phase 1 environmental site assessment, which has to do with due diligence, and Kim will discuss that in more detail later. Lenders may be less willing to lend money on contaminated property if the cost of remediating the contamination could exceed the property value. Next slide. So defenses are especially important in real estate transactions because liability immediately attaches once someone becomes an owner, whether or not they caused the contamination or operated the site when contamination took place. Defenses to CERCLA liability are limited to cases in which the release was caused by an act of God, acts of war, or acts or omissions of a third party with whom a potentially responsible party has no contractual relationship. This third category is known as the third party defense, which can take the form of three defenses. First, the bona fide prospective purchaser defense. Second, the lender defense. And third, the contiguous property owner defense. And I'll discuss each of these in a bit. More on this third party defense category. To assert this defense, a defendant needs to satisfy the following four requirements. The release was solely caused by the third party. The defendant had no direct or indirect contractual relationship with the third party. The defendant exercised due care with respect to the hazardous substances. And lastly, the defendant took precautions against the foreseeable acts or omissions of third parties. As for the second element, a contractual relationship with the third party may include providing an indemnity to the seller of the property who is a potentially responsible party. It's important to note that once you provide an indemnity to a potentially responsible party, you may no longer be eligible for the third party defense under CERCLA. Next slide. The contractual relationship language in the third party defense element was problematic in real estate transactions, so Congress created a subset of liability protections known as the innocent landowner defenses. The innocent landowner defense applies to innocent landowners who purchased previously contaminated property and did not contribute to the contamination, as well as those who acquire a property by inheritance or bequest. A contractual relationship is deemed to not exist when a purchaser does not know and has no reason to know of the hazardous substance contamination at the time of purchase. Next slide. To be eligible for this defense, a landowner needs to demonstrate that they acquired their property after all hazardous substances were disposed of at the facility. Before acquisition, the landowner conducted all appropriate inquiries into the property's prior ownership and uses, consistent with the ASTM 1527 standard, and Kim will talk more about what that is later. The landowner did not know and had no reason to know of the hazardous substance contamination at the time of purchase. The landowner exercised due care regarding the hazardous substance, taking into account its characteristics in light of all relevant circumstances. The landowner complied with all continuing obligations after acquiring the property, and the landowner took adequate precautions to prevent foreseeable third-party acts or omissions and the foreseeable consequences of these acts or omissions. As a part of the elements of complying with all continuing obligations after acquiring the property and meeting all post-purchase requirements, the purchaser must provide all legally required notices with respect to the discovery or release of a hazardous substance, take reasonable steps to stop or prevent continuing or threatened future releases and exposures, and prevent or limit human and environmental exposure to previous releases, provide full cooperation, assistance, and access to persons authorized to conduct response actions or natural resource restoration, comply with land use restrictions and not impede effectiveness of institutional controls, and comply with information requests and subpoenas. And with regard to the all appropriate inquiries requirement, EPA's final rule requires that all appropriate inquiries be conducted or updated within 1 year prior to acquiring the property. However, the final rule also requires that certain activities be conducted or updated within 6 months prior to acquiring the property. The general rule of thumb is that a Phase 1 environmental site assessment is stale after 6 months and must be ordered by the party relying on it. Phase 1 environmental site assessments have to do with due diligence. I think I mentioned that before. And also for a beneficiary of a trust or estate to qualify as an innocent landowner, they need to satisfy similar requirements, but with two key distinctions. Of course, the beneficiary must have acquired the title to the property through inheritance or bequest. And unlike purchasers, beneficiaries are not required to conduct all appropriate inquiries prior to acquisition, since the transfer occurs by operation of law rather than through a voluntary transaction. Next slide. Next, we're going to move on to the bona fide prospective purchaser defense, which is one of the third-party defenses. The Brownfields Amendments, also referred to as the Small Business Liability Relief and Brownfields Revitalization Act in 2002, established this defense to CERCLA liability, which affords a person protection even if that person purchased property with knowledge of its contamination. Prior to the Brownfields amendments, a person who purchased property with knowledge of the contamination was subject to owner or operator liability under CERCLA. A bona fide prospective purchaser is a person who acquires ownership of a facility after January 11th, 2002, which was when the law went into effect, and who establishes the following by preponderance of the evidence. First, the hazardous substances disposal occurred before the purchaser acquired the property. Second, the purchaser made all appropriate inquiries into the previous ownership and uses of the facility. Third, the purchaser complies with all continuing obligations after acquiring the property. Fourth, the purchaser has no affiliation with any potentially responsible party. And lastly, the purchaser meets all post-purchase requirements. In practice, California agencies like DTSC or Regional Water Board often want to ensure that there is a financially viable party actively managing the cleanup at a contaminated site. If another PRP or potentially responsible party is already performing the cleanup, the agency may be more inclined to recognize a bona fide prospective purchaser. However, even if a party meets all of these requirements, they still may be subject to agency enforcement or cleanup demands unless they proactively assert their bona fide prospective purchaser status and demonstrate compliance with post-acquisition obligations. And with regard to that element involving the purchaser's lack of affiliation with any potentially responsible party, affiliation includes direct and indirect familial relationships and many contractual corporate and financial relationships, but excludes contractual corporate or financial relationships created by the instruments by which title to the property is conveyed. An entity cannot be a bona fide prospective purchaser if it's the result of a reorganization of a business entity that was potentially liable. Next slide. Next, we'll move on to the contiguous property owner defense, which is another third-party defense under CERCLA. The Brownfields amendments exclude from the definition of owner or operator a person who owns property that is contiguous or otherwise similarly situated to a facility that is the only source of contamination. A party seeking to assert this defense needs to demonstrate that the person did not cause, contribute to, or consent to the release or threatened release of hazardous substances. Once again, that the person made all appropriate inquiries into the previous ownership and uses of the facility. The person did not know or have reason to know that the property was or could be contaminated by a release or threatened release of hazardous substances from other property not owned or operated by the person. The person complied with all continuing obligations after acquiring the property, and that the person had no affiliation with any potentially responsible party. So there are some similar requirements here as under the bona fide prospective purchaser defense. Next slide. The last third-party defense under CERCLA is the secured creditor or lender defense. And this is a two-pronged test. First, a person must qualify as a lender, and second, a person must not participate in management. A lender holds a security interest, such as a mortgage or deed of trust, primarily to secure the repayment of money or other obligation of another person. A lender is deemed to participate in management if it undertakes decision-making control or responsibility for the facility's hazardous substance handling or disposal practices, or exercises control at the level of a manager over day-to-day decision-making with respect to environmental matters or the operational functions of the facility other than the functions of environmental compliance. Actions that don't qualify as participation in management include holding, abandoning, or releasing a security interest, including environmental covenants or warranties in a credit or security agreement, monitoring or enforcing or altering, restructuring, or renegotiating the terms and conditions of the extension, credit, or security agreement, conducting one or more inspections of the facility, requiring a response action or other lawful means of addressing the release or threatened release of a hazardous substance, providing financial or other advice or counseling to mitigate, prevent, or cure default or diminution in value, and exercising other legal remedies for the breach of a credit or security agreement. Next slide. The CERCLA 1996 amendments also added a safe harbor for lenders even after foreclosure on a contaminated property. To qualify for the safe harbor, the lender must not have participated in management of the facility before foreclosure. And as I mentioned before, after foreclosure, the lender must be able to show that it's made commercially reasonable efforts to divest itself of the property at the earliest practicable commercially reasonable time, taking into account market conditions and legal and regulatory requirements. It's also worth noting that the lender is entitled to act as the property owner before divestiture, including by taking actions to sell, release, or liquidate the facility, maintain or wind up the operations of the business, lawfully address releases of hazardous substances, or take other measures to preserve, protect, or prepare the facility before sale or disposition. It's a good idea for lenders to document all efforts to market and sell the property in case of a later challenge to its protective status under this safe harbor. And I'll go ahead and hand it over to Kim to discuss a case study involving contamination discovery during a property sale.
Thank you, Heather. So hopefully you all can keep all of that information in the back of your mind while we go through this case study, but I will remind you of some of the important points that Heather has made. Let me just first put forth a disclosure that this is a hypothetical case study created entirely out of my own imagination, not based on any facts in real life, not based on any real sites. And any advice that's given through this case study is not to be construed as legal advice pertaining to any real matter. I would recommend that you not provide legal advice until you look at the cases, the facts in your own case very carefully. So don't just take what I'm saying as what you can apply directly across the board. All right, the facts in our case study. We have an owner that has bought property back in 1991. They conducted a phase 1 at that time. And the phase 1 in 1991 did not identify any recognized environmental conditions. So it was a clean phase 1. The owner at the time purchased the property thinking that they were buying a clean property. They had no reason to believe that there was any contamination on the property. And just as a quick point here, the phase 1s, well, I'm going to talk about a little bit more, but they were pursuant to a standard that was first created in 1990 by the Association of Standards for Testing, hang on a second, Association of Standards Testing Materials, American Society for Testing Materials. I forgot what this acronym stood for, ASTM. That standard was created in 1990, and at the time, the standard did not require identification of prior site uses or operations to determine if there were any recognized environmental conditions. So the standards were different in 1991. That's important for this fact pattern. In addition, the owner purchased the property and then created a manufacturing facility on it, which they only used water-based products. They did not use any solvents or chemicals such as TCE and PCE. And then they operated it for 33 years, decided they're ready to retire, and put the property on the market for sale. Now, I would just like to point out here before I go on to the next slide that if at some point in time before this, the owner had been sued by another party, or an agency had come after them saying that they needed to sample their site, they would be able to assert the innocent, or they would likely be able to assert the innocent purchaser defense based on their 1991 phase 1, which at the time was sufficient for all appropriate inquiry. However, at this point, in the fact pattern, they don't even know that there's contamination on the property, so they don't know that they're an innocent purchaser, and they don't know that that defense would help them at all, and it may not. Okay, I quickly started to talk about the American Society for Testing Materials, tripped over the acronym, so glad I was able to recover that. It is a standard practice for environmental site assessments, phase 1 environmental site assessment process. The American Society for Testing Materials is recognized by EPA as the standard for establishing all appropriate inquiry. It requires a qualified environmental professional to conduct it and sign off on it. Heather's already mentioned that a phase 1 ESA has to be relied upon only by the person who's ordered it. So if somebody else cannot rely on the results of the phase 1, you'd have to have a new phase 1 done if you are not the one that ordered that phase 1. I've already said that it was initially established in 1990. And in 1990, the recognized environmental condition was defined as the presence or likely presence of any hazardous substances or petroleum products, which is not covered by CERCLA, but is covered by this, on a property under conditions that indicate an existing release, a past release, or a material threat of release into structures on the property or into groundwater or surface water of the property. So that was what was a REC at that time, an REC. And that did not specifically call out prior property uses or operations that existed, or prior companies that owned properties, to determine whether or not there was a presence or likely presence of hazardous substances. So the mere fact that a dry cleaner or some other type of operation might have owned or operated the property would not be enough on its own. There would need to be evidence of a reasonable or evidence or a reasonable basis to believe that there was a release that occurred, or that there's a threat of release that is a material release, significant enough to be material. So since 1990, the standard has been updated every 6 or 7 years. The most recent update was in 2021, and prior to that it was 2013. And now the 2021 standard explicitly requires the evaluation of prior uses and prior owners of the property. The new section 8.1 of the ASTM E1527 standard states that the objective of the inquiry of historical uses is to develop a history of the previous uses of the subject property and surrounding properties in order to help identify those uses that are likely to have led to recognized environmental conditions. So now we're in 2021 and we're operating under this new standard. I'm going to take a step back and do a reminder of the primer, fill in the primer that Heather passed off to me about phase ones. So just a quick step back. Phase one environmental site assessments are strictly what you can see, what you can visually see through a site tour, looking at the ground, looking at staining on the ground if there's any, looking at appurtenances or pipes that are coming out of the ground that might signify tanks or other types of operations. And also what you can visually see in records and databases that are online or available at the site, documents that might be available at the site, and also what you can find out from interviewing potential employees, past or current employees at the site, if that's available to you. So phase one is only what you can see without digging into the ground. That's a very important distinction because a phase two is what you can see once you dig into the ground. Phase one is required for all appropriate inquiry and for all those defenses that Heather just covered. A phase two is not required. However, I'm going to get into not just the question of whether you have a defense, but whether you can sell the property. And a phase two might be needed for that. So it may not be needed for all appropriate inquiry, but it may be needed to get that property sold. Phase two usually includes soil and soil vapor sampling to test for contamination, also potentially groundwater sampling. And a buyer often wants to have it done before a purchase so they can collect data and calculate what the future risk of costs might be for the site before they decide to buy. All right. Minor detour to the primer is out of the way. We're back to case study. Now we are in 2021 and we have a prospective buyer for the property. The prospective buyer decides, of course, recommended and they follow good advice of counsel to conduct a phase one as part of their due diligence so that they can meet their all appropriate inquiry requirement. Their consultant performs the phase one in 2024 and finds that there was a dry cleaning operation at the property in the 60s and 70s based on a database search, titles and operations. And using the ASTM standards in 2021, that prior dry cleaning operation would be considered a recognized environmental condition, triggering a recommendation by the consultant to conduct a phase two. So a phase two would be to determine whether or not there is actually contamination as a result of this prior use. Phase one just tells you that there is potential for that contamination, not that there is one. In addition to, just to make this case study a little bit more interesting, we added in that the phase one also found that there was sampling had been conducted in the area and that there are possible adjacent properties that have reported groundwater contamination. So you have a potential source on site with a prior operation of a dry cleaner, potential sources off site for adjacent properties. Both of those would be recognized environmental conditions and would justify pursuing a phase two. Again, it's not required. So after the phase one, even though it does not identify any visual signs of release on the property, it does identify the prior operations and the regional potential adjacent property contamination. So I've already covered this. The buyer may decide that they really need a phase two to determine what is at the property itself, what is underlying the soil and groundwater and soil vapor, to determine if there are costs that will be incurred after they purchase the property. The buyer would probably like to have a phase two. The seller is probably going to have to agree to that because that's the only way they're going to get this property sold. So if that's the case, for the buyer's comfort that phase two is going to be required, then the buyer's consultant can conduct the phase two pursuant to an access agreement that's negotiated between buyer and seller, or the seller's consultant can conduct it and share the data with the buyer. Either way, both parties were going to want to get that data. They can do it by taking split samples, both consultants going on the property together, taking split samples, or by sharing the information through their access agreement and through a confidential sharing process. Sometimes the control of the flow of information is important to the seller, but I would point out that if there is contamination that's identified in a phase 2 and the seller does not know about that contamination, that does not necessarily protect the seller from potential reporting requirements. Reporting requirements in California require any person who's identified the contamination, if they have control over the property, they're required to report. So there are arguments that could be made that a buyer would still have to report if they're the ones that collect the data, even if they don't share it with the seller. There's also arguments that that knowledge is imputed onto the seller. So if a seller says to you, I don't want to see the data, I'll let the buyer take the samples and they can hold on to the data, not share it with me, that's not necessarily going to protect them in the long run. There's also an argument that they will protect them in their main goal of selling the property, because they're going to need to know what the costs are going to be involved with contamination if they find it underground. Okay, moving on. I think that I've already covered phase 2. Now we're in the phase 2. All right, so now in this fact pattern, we're now finding out what's underground. In this case study, they've discovered TCE and PCE, not surprising because of the dry cleaning operation, are identified above screening levels in the soil vapor at depths that are greater than 5 feet below ground surface. So at depth, deeper than just the top layer of the soil. And just to make this interesting, we have that there's no TCE and PCE found in the soil itself. So only in the soil vapor. That's the area that's in the interstitial areas between the soil particles. If it's in the gas phase, different than what's in the soil as a liquid phase holding onto the soil. So in this case, I would say the seller is going to likely assert that the lack of soil contamination and the lack of shallow soil vapor contamination is evidence that there's a source coming on site from the offsite properties, and that there's not a source on site itself, because if there was a source on site, then it was possible that the soil itself would be contaminated. That's a factual argument that would have to be made by the consultants to determine whether or not that actually flies, but that's an argument the seller would probably make. And they would probably argue that there's no need to have groundwater sampling done. However, the buyer is likely to insist on groundwater sampling to confirm whether or not there is TCE and PCE in the groundwater underlying the property, regardless of the source, especially given the fact that there's contamination in the region. So in this case study, the seller is motivated to sell. They want to get off to retirement, and they agree to sample the groundwater, and that sampling reveals that there are elevated levels of TCE and PCE. Further investigation would be required to identify a source. At this point, we don't know if the source is the dry cleaner or the source is the regional area or the adjacent properties. So after the phase 2, the first question is there more investigation necessary? The buyer might want to continue to pursue determining where the source is of this plume. The seller might say that that's not necessary. There's going to be negotiation. There's also going to be the question about whether reporting is required. Now, Heather's going to cover that in a minute, but this can become a negotiation between buyer and seller if it's not clear that reporting is a requirement under the law. And I'll get into why that's the case with voluntary cleanup agreements. They're also going to probably want to look and see if there's someone else that they can turn to help pay for this, or at least see if they can tap into some other remediation that's going on. If there's an adjacent property owner that's conducting remediation already, there might be a potentially responsible party that they can talk to bring in to take care of the problem on the target property. Or there might be prior property owners or prior property operators like the dry cleaner who might be available still insolvent to help pay for the investigation and potential future remediation and mitigation of the contamination. They also may be able to access historical pre-1986 commercial general liability insurance policies. This is pre-86 is before the pollution exclusion wiped out all environmental insurance from the CGL policies. So the current owner would not have access to that because they didn't buy the property until 1991. But the dry cleaner that operated previously in the 60s and 70s may have insurance available if that dry cleaner still exists and is not dissolved or bankrupt. And if that dry cleaner exists and did have insurance policies, then there would be necessary to tender the claims within the time period required. And so I put this in here because I'm not an insurance lawyer, and you would need to contact an insurance lawyer, but it is something you need to do as soon as you find out that there's a potential claim. All right, possible reporting. I think this is where I hand off to you, right, Heather?
I can take it from here.
All right, take it away.
So as Kim indicated, there may be reporting triggered after receiving the results of a phase 2 environmental site assessment. If the sampling results indicate that there is contamination of soil, soil vapor, indoor air, or groundwater that threatens public health and safety, then the property owner should immediately report those results to the Office of Emergency Services. And if there's a threat of fire or explosion, it would be advisable to call 911. Note that in this case study, if the seller's consultant determined that the contamination does not threaten public health and safety, then no emergency reporting is likely required. Next slide. And even if there is no threat to public health and safety, but there is evidence of a single release of a hazardous substance in a 24-hour period exceeding the reportable quantity for that hazardous substance, then CERCLA requires immediate reporting to the National Response Center as soon as there's knowledge. Also in California, there's a non-emergency release requirement that within 30 days from discovery, the release should be reported to DTSC in writing unless the release is permitted or authorized by law, was previously reported, or occurred prior to January 1st, 1994. In the case study, the only possible time frame for a release on the property would be before 1994, and because there's no significant threat to the public or the environment and no reportable quantity, no reporting is likely required. Next slide. CERCLA's reporting obligation for pre-existing contamination applies only if a specific release event can be identified as the source, and if at least one such release exceeds the applicable reportable quantity within a 24-hour period. In practice, it's often really difficult to quantify the volume of contamination and link it to a single discrete release within a 24-hour time frame. Contamination may result from small continuous releases over time, which aggregate in the subsurface and may appear equivalent to a single larger spill. Unless there's evidence, such as historical documents or employee interviews, of a sudden identifiable release over the reportable quantity threshold within a 24-hour period, the reporting obligation is unlikely to be triggered. In the case study, there's no information of a single spill event or data to quantify a release exceeding a reportable quantity within a 24-hour period. So no reporting is likely required under CERCLA. Under federal law, if a single release of a hazardous substance occurs within a 24-hour period and the quantity released equals or exceeds the applicable reportable quantity for that substance, then the release needs to be reported to the National Response Center. A reportable quantity for each hazardous substance is listed in CERCLA regulations at 40 CFR Table 302.4. For example, trichloroethylene, or TCE, has a reportable quantity of 100 pounds or 45.4 kilograms. Sometimes the release, however, is not of a single hazardous substance, but is of a mixture, and in that case, the reportable quantity is calculated based on the concentration of each hazardous substance component within that mixture. In the context of real estate transactions and phase 2 environmental site assessments, it's not always straightforward to determine whether a release exceeds a reportable quantity. If there's a single discrete release from a container with a known volume or concentration, it may be possible to quantify the release and assess whether it meets or exceeds reporting thresholds. However, in most phase 2 investigations where contamination is identified in soil or groundwater without a clear point source or volume, the data often does not immediately establish whether reportable quantities have been exceeded. As a result, it's common for phase 2 findings not to trigger immediate reporting obligations. In the case study, there is no discernible reportable quantity, so likely no reporting is required. Next slide. California reporting obligations are similar to the federal reporting obligations because they're incorporated into the Hazardous Substances Account Act for hazardous substances that exceed reportable quantities. However, in addition to these reporting requirements under federal law, which involve reporting to the National Response Center, You also need to report to the Office of Emergency Services for significant or emergency releases and the Regional Water Quality Control Board if groundwater or surface water contamination is involved. Reporting may be tricky because you may not know if a reportable quantity has been exceeded or if it's been exceeded within a 24-hour time frame, especially with phase 2 environmental site assessments. However, there are significant penalties for not reporting. For example, you can be subject to up to $25,000 in civil penalties per day and potentially increased liability for cleanup costs. In the case study, there's no discernible reportable quantity, so there's likely no requirement to report under California law either. And I'll go ahead and hand it back over to Kim to talk about identifying other potentially responsible parties and potential funding sources for site remediation.
Thanks, Heather. Actually, I'm going to pivot a minute and talk about voluntary cleanup agreements, because even though you may not be required to report, you might opt to report. And there's a good reason to do that. That's if you report your contamination, you have the option of entering into a voluntary cleanup agreement with either DTSC or the Regional Water Quality Control Board. And when you do that, the benefit is the investigation and remediation work is approved by the agency. You have more flexible deadlines that you're working under, and you don't have any penalties or fines for failing to meet a deadline. So it's more of a cooperative, collaborative approach to conducting an investigation and remediation work at a site. The cost of doing that is that the property owner or the individual that enters into the voluntary cleanup agreement has to reimburse the agency for their oversight costs. But the benefits are tremendous because it leads potentially to the opportunity to obtain closure or no further action from the agency once all of the work is complete. And once you have no further action, to the extent you can get that, the property is much more attractive to sell because it can be sold again, the no further action letter. I will just have a footnote that no further action letters are hard to come by, and they typically do have some kind of exception or clawback clause. So don't get too excited about no further action, but the opportunity to actually get a no further action letter typically comes from a voluntary cleanup agreement. So if there is voluntary reporting of the contamination, it would follow that the property owner will seek a voluntary cleanup agreement. In this case study, the seller is probably interested in that because that would give them an opportunity to help sell the property. The other option is that the buyer could negotiate a bona fide prospective purchaser agreement with the agency. If it's DTSC, DTSC tends to enter into these more than the regional board, but that would be another option if seller or buyer are both willing to sign on to one of them paying for the cleanup work to be done. So remember from Heather's discussion about the bona fide prospective purchaser agreement, someone has to be in agreement to pay for the work. The seller can agree to pay for it and the buyer can get the bona fide prospective purchaser protection, or the buyer can agree to pay for it and get the bona fide prospective purchaser protection, but somebody has to agree to pay for the work. The state's not going to do it. I already think Heather talked about what you need to do as a bona fide prospective purchaser, but I will just point out that if the buyer decides to go down that road, they will have obligations after they purchase the property, the continuing obligations during their ownership. And Heather already covered those, so I'm not going to cover them again, but they don't get to just walk away and be done. They have to continue to comply with the requirements of the bona fide prospective purchaser agreement itself, including providing full cooperation and assistance and access to the site and conducting, complying with all information requests and conducting appropriate care with respect to hazardous substances use at the site, et cetera. Okay, actually, I'm going to jump to deal negotiation. So while all of this is going on with the remediation, investigation and remediation is happening, this is all in the context of this site needing to be sold. The owner of the property wants to sell the site and they want to retire and go off into, enjoy life and not have this hanging over their head. That means that during this process, they've been trying to negotiate a deal with the buyer. And at the same time that they're trying to negotiate with the agencies how to comply with a voluntary cleanup agreement, if they're entering into that, they're also looking at how do they get the buyer to get on board and buy this property. So what's probably going to come next is that the consultants will be asked to provide a remediation cost estimate, or an RCE, to both buyer and seller. And each of their consultants will provide their own idea of it. The buyer's is going to be as high as possible, and the seller's is going to be as low as possible, but they're Both should be rational and reasonable and based on the facts. And that would be to respond to soil vapor contamination and potentially monitor groundwater contamination, potentially participate in remediation of the groundwater contamination, but because this looks like it's a regional site, that might not be required. All of the things that they would cost out would be things that they would do in a voluntary cleanup agreement. So for example, there would be a soil management plan for any future construction, making sure that the soil itself, if it's moved, is tested and sampled and disposed of properly, or is put in an area that's safe. Vapor barriers would be required in new construction that could be either active or passive, but vapor barriers prevent the soil vapor from coming through the soil and up into the foundation and into the buildings. Indoor air sampling would be required after any new construction of buildings on the site to make sure that the buildings are habitable and safe. And then groundwater monitoring would probably be required, and maybe remediation. It's hard to tell with this fact pattern. I've left that kind of vague because that would end up being a bit of a negotiation with the owner of the property and the agency that they're working with, and also between the owner of the property and the buyer of the property. And finally, the costs are associated with agency oversight. There's assumed to be agency oversight at some point in time in this case, and so there would be costs associated with that, and those would be part of the remediation cost estimate that would go into the total cost that the buyer would potentially have to inherit, or that the seller would have to agree to pay in order to get this deal done. Now, that RCE would be used by the buyer to seek a discount in the purchase price. And the alternative is the seller might say, well, we'll agree to pay some portion of that, what we think is reasonable, but we're not going to just give you the money to put in your pocket. We want to make sure that that money goes to a place that's getting used for the actual purpose of cleaning up the site. So they would put that into an escrow account. And sometimes the escrow accounts can be limited in time, 5 years, 10 years, whatever time duration they think is necessary to get the work done to remediate the site. And at the end of that time, the money can revert back to the seller, or the seller can agree to let the buyer keep that money. It depends on the negotiations, how they play out. The benefit of having an escrow account is that the buyer knows that they have a source of funding to go to, and they don't have to go after the seller to comply or to provide the funds or to actually perform the work. And the benefit to the seller is that they have certainty that the work will get done. And the reason they want to make sure that whatever work is required gets done is because they're still going to be on the hook even after they sell the property. They'll be a past owner operator. And as Heather pointed out, that's still a liable party under CERCLA and under the California analog. So the seller is potentially on the hook no matter what, even after they sell the property. They want to make sure it gets cleaned up right and that they're not subject to future liability. The buyer also might seek insurance, like a pollution legal liability policy, to cover unknowns. And if they do that, the seller will probably want to be an additional insured to one of those policies. I think I've already talked about that. Let's see. Just to get back to the seller and buyer placing funds in an escrow account, the buyer also may want to be indemnified by the seller and vice versa, seller is indemnified by buyer. Typically, there's a price to that. So if the buyer is taking on the liability, they're getting a discount on the price, or their money being put in escrow for them to use to pay for the remediation. Let's just say that this site is valued at $4 million and the cleanup, investigation and cleanup and oversight costs are going to be $1.5 million. So the buyer would ask for $1.5 million to be placed in escrow. And they would also want the seller would also want to be indemnified because now they are paying for that work to be done by the buyer. So they want to have an indemnity. If instead the seller says, I'm going to do the cleanup myself and you can buy the property and I will cover the cleanup, but I want full price for the property. So I want my full $4 million. Then the buyer is going to want an indemnity from the seller and probably also want to have money in escrow in case the seller doesn't do the work they're supposed to do. So that's just another way that this RCE is used in negotiations. Sometimes the parties think that the indemnities are free, but they come with a cost, and the cost is usually whatever it's going to be to clean up the site. I think we're doing good on time. Allocation of risks and deal documents. So just real quickly, and I apologize, I didn't go into it. Heather promised I would talk about searching for PRPs. I think identifying sources of funds. The PRPs are going to be whoever's around you in the adjacent properties and also the prior former property owners and operators. I think I covered that in one of the earlier slides. Looking for funds. So we've already talked about funding from those types of parties, environmental insurance, and then the funding from the actual seller himself, him or herself, who's potentially going to sell the property, getting money from the deal. That's, I think, usually the best way to look at how to get this deal done is how do you allocate the risks and the costs? And it all comes down to the bottom line of the dollar. How much money are you willing to pay, or how much money are you willing to give up in order to make this deal go forward? The way to allocate the risk and deal documents is going to be through reps and warranties, representations and warranties by the seller, which they're going to want to be as narrow as possible, and the buyer will want to be as broad as possible. And if the seller breaches the reps and warranties by making a statement that is not true, the buyer does have recourse through contract law to sue for breach of warranty. Separately, the indemnities and releases, I've briefly talked about indemnities already. Both parties will want to have a mutual release against each other so that they don't sue each other later. The indemnities are, as I said, going to help decide who's going to take on the cleanup and do the work. But as I already said, the indemnities are only as good as the party behind it. So there's always a question about whether or not that party is going to be solvent in the future, and if there's any protections you need to have to make sure that you have those funds available if they're not. And that's where the escrow accounts come in, which we've already talked about. Environmental insurance, I apologize if I've already covered this, but environmental insurance can be expensive and can have terms that are not as long as the liability could long tail liability could take. If you have a property that, in this case, this is not the type of case study that would have it, but if you had a property that had a RCRA site that needed a facility that needed to be closed in 30 years, it's going to be difficult for you to get environmental insurance to help you with a closure 30 years from now, because most of these policies term out 5 years to 10 years, and there's no guarantee that you can get a renewal. For this case study, you could probably get an environmental insurance policy for the next 5 to 10 years to cover unknowns that are not discovered during the course of phase 2. Unknowns might be other types of contaminants that weren't tested for. I will tell you, though, that the insurance companies will want everything tested for, and if it's not tested for, they're going to carve them out as an exclusion in their policy. So that's a kind of a conundrum with environmental insurance. It's also expensive, but it can be the one thing that seals the deal, makes it go forward, is to have environmental insurance that gives some assurance that you're not taking this big leap of faith, that it's not going to be this incredible cost down the road for the buyer. And then finally, covenant insurance is a new product that's on the market. I actually have not seen it used yet, but I've negotiated some deals where it's been proposed. And it's basically insurance of the covenants that are made by each party in the purchase and sale agreement. So if a buyer covenants to conduct the remediation and indemnifies the seller for that work, the seller may want to get covenant insurance to protect themselves in case the buyer does not actually conduct the remediation. In case the buyer decides to not do it, goes belly up, becomes dissolves, then they would not be able to do that work. Then the covenant insurance would cover the work that they were supposed to do. I think it's very expensive and it's kind of hard to find, but it's an interesting new mechanism out there to make sure that the parties feel safe and secure that the promises that they're being made are going to actually be fulfilled. And I went ahead and put in some sample reps and warranties here. This is in brackets, I have the seller's request for how they would limit their reps and warranties to seller's knowledge. A buyer would want to take that out, and that would be hotly disputed and negotiated. Typically, it's included in the long run, but it just depends on how much the buyer really does not trust the seller. If the buyer trusts the seller, then they'll go ahead and go with the seller's knowledge. So there's with the knowledge requirement, they would rep and warranty that there's no environmental claims or environmental liabilities or violations of environmental laws, except as disclosed, and there would be a disclosure list or a disclosure set of documents. And then the other one would be that they delivered all of their documents regarding the environmental reports, et cetera. Typically, the seller wants to carve out any draft copies or any attorney-client protected copies, but most reports are not attorney-client protected if they're just phase 1s and phase 2s. And then the final one that I've got here, there's many other ones that you could include, but these are the 3 key, is that the seller has no knowledge of any presence of hazardous substances on the property. And the seller will want to exclude cleaning and maintenance products that they have because they don't want to have to disclose all of those. So those are 3 possible reps and warranties that the seller would provide to give the buyer comfort. And then the final slide is a sample indemnity. This could be buyer or seller, basically indemnifying them for any and all claims related to environmental liabilities, related to the physical or environmental conditions of the property. And this is a full indemnity prior to, on, and after closing. And you would also need to have terms of survival to make sure that it says that this would survive the closing of the purchase and sale agreement. The reps and warranties would also survive, so that would be part of the negotiation of the terms. Leave this up here for just a minute for people to take a look at. And I would just make sure that I always want to double check. I get these clauses, I look at them all the time, and I always want to make sure that the common law claims are included in there. That's just one don't want to forget about that. We're all focused on what the enforcement orders are going to be, but there's also potential common law claims from third parties. So you want to make sure that those are in this indemnity as well. And as I said, the seller can have the exact same indemnity, a mirrored indemnity. And I think that leads us to questions. And Miles, I'm going to have to confess that I'm not sure how to see the questions.
Yeah, thanks, Kim. Thanks so much, Kim and Heather. I can read the questions to you. And for those on, there's a Q&A feature. So if you have a question, please type it in and submit it in the Q&A function. And Kim, maybe you can progress to your final slide with your contact information, just so that's...
Get that deal done? Okay.
Perfect. Great. So our first question, and I think you've touched on some of the information in all these questions, but good to hear it again. Can a party rely upon a phase 1 prepared by another party if that party can get a reliance letter from the phase 1 provider?
I mean, under the law, I think the answer is no. I think you have to get your own phase 1. But I have not actually looked at that before to see. I'd have to do a little research. So if that person can send me an email, I'll take a look at that and get back to them. Heather, do you have any idea?
Yeah, I would have said the same thing. Follow-up research.
Okay, great. Well, excellent question. And yeah, you can follow up directly with Kim and Heather. Their emails are on the screen regarding whether there can be a reliance letter from the phase 1 provider. The second question, a discussion of environmental insurance in transactions would be useful. I think this question came in earlier on during the PowerPoint, and you covered it later on, but do you want to cover anything again, Kim or Heather?
Sure. So I run into environmental insurance quite a bit. And sometimes it's just too expensive. It doesn't pencil out because the cost of the premium is going to far exceed what the cost of the cleanup would be. But if you have a cleanup that's substantial money-wise, or you just have uncertainties and unknowns that you just cannot resolve in time to make the deal close, to the extent you can get environmental insurance for that, for those uncertainties and those unknowns, it's sometimes worth the cost, the price tag. And I would say, if anybody wants information about that, they can reach out to me. I've got several brokers that I work with. I will say that it's tricky. The brokers usually go out to bid with multiple carriers and they come back with various options for you. And you look at whether the premiums are higher, but the terms are lower or the exclusions are greater, et cetera. And I have seen them exclude things like PFAS. So PFAS is now a hazardous substance under CERCLA. It's been identified by EPA. So now it is required in scope in a phase 1, and a phase 1 has to say whether or not there's potential for PFAS contamination, which means that if you did a phase 2 as follow-up, you would need to sample for PFAS. But prior to this listing, I did have insurance companies that would carve out and exclude any PFAS contamination unless you sampled for PFAS. So there might be other emerging contaminants down the road that we don't know about that you haven't sampled for. And typically they will, if they know what they are, they'll carve them out if you haven't sampled for them. If no one's heard of them yet, then that might be a way to get insurance coverage for them.
Great. Thank you, Kim. The next question, I think the hypothetical, depending on the soil gas, I think in the hypothetical, depending on the soil gas results, there could be an indoor air issue, which could result in a human health issue, and depending on the indoor air results, could end up being reportable. Is that correct?
Yes, that's a good point, and we probably should have covered that. Indoor air would be part of the phase 2. It would probably be, sometimes it's preliminary before phase 2. So after you have a phase 1, if you have evidence that there's potential for indoor air, well, in this case, it was the phase 2 that presented the evidence of potential indoor air. There would be an immediate human health risk assessment conducted, which would include an indoor air sampling event. And that would definitely be required by the agency as well. If you were to report to the agency, they would want to see what the indoor air results are. We could do an entire webinar on indoor air sampling and how that gets analyzed by the agencies and the risk factors that they take into account. But it is true that once you have that indoor air sampling done, you'll know whether or not there's an immediate threat to human health. Given the lack of soil vapor in the upper area, in the top 5 feet of the surface, it's not necessarily likely that there'd be indoor air problems, but you don't know until you sample, so you would want to sample.
Thank you. The next question is sort of a comment, but you may want to respond to it. So one thought on the hypothetical, if the seller is lucky enough to consult a savvy lawyer before entering into the purchase agreement, the seller may want to get a preliminary sense of what the potential for RECs would be since they bought it so long ago. That way, depending on the potential purchase price and very rough potential environmental liability, they can see what they are getting into.
Very good point. That must be a savvy lawyer who asked me that point. I have another case so it's not the same site, not the same facts, because I didn't want to copy any of my existing cases. But one of my favorite clients actually called me about 8 years ago and wanted to get ready to sell property and a company. And we did a full-scale audit, compliance audit, and audit of the site itself, so that we knew exactly what we were getting ourselves into and could price it accordingly. We didn't want any surprises. And so that is a savvy seller. Unfortunately, those are few and far between. I would love to say that there's some real estate developers out there that are very savvy, but there's also a lot of mom and pop shops that are looking to sell their property, and they're very surprised and do not understand why they are liable for contamination that they did not cause. And that's kind of the fact pattern that we put here.
Thank you. There's 2 more, and then I have one quick question. How long does it normally take to negotiate and sign a voluntary cleanup agreement with a state agency like the Department of Toxic Substances Control, or DTSC?
I would love to say not long, and my recent experience has been not long, a month or so, 6 weeks. But the DTSC does have some time lag just because of their work is they're just overworked, basically what it comes down to. So I can't really predict necessarily today what it would take, how long it would take. Usually if you're entering into a voluntary cleanup agreement, you want to send them all the documents you have for what you've got, what you know now. So the phase 2 reports, the indoor air sampling, if you've done that, and I would recommend that be done. If you've done a human health risk assessment, send that as well. Anything that you've done already, they're going to look at that and they'll say, okay, this is something we can get ourselves behind and help with, and it will go faster. After they enter into the voluntary cleanup agreement with you, they're going to then ask you to do more work. And some of the work that you've already done, they might use for the work that they would require. So that can help you. But I would say a month to 6 weeks to get their attention to actually get an agreement signed. And then after that, things take longer. That's just a guess.
Thank you.
Don't hold me to it.
Thank you. We had an additional one come in, so 2 more. Does accepting property as is affect your innocent purchaser CERCLA protection? Does providing an indemnity to seller impact CERCLA protection?
No, CERCLA doesn't care. You are liable regardless of your contractual negotiations with parties, and you are liable regardless of an as-is warranty. As-is does not mean anything under CERCLA. If the property is contaminated and you own it, you are liable. If you're a current property owner, you're strictly liable. If you're a past property owner or you become a past property owner, you're liable to the extent there were releases of hazardous substances during your ownership. And there are arguments that contamination moving from one piece of soil to the next piece of soil is considered a release. So pretty much any past owner of property is potentially liable and could incur legal fees trying to defend themselves. The indemnity would mean that if you are sued or an enforcement action is brought against you by an agency and you have an indemnity from another party, you can tender that indemnity to that party to take over, represent you, or pay for your fees, pay for your costs, but you are still a liable party under the law.
Thank you. So one more question here, and then I just had one short one. If contaminants are believed to have migrated from one property to another, for example, by groundwater, would the responsibility as the current owner extend to liability to clean up a neighboring property onto which contaminants may have traveled?
I'm going to say yes, but it's always dependent on the facts and whatever the law is in place, how that's affected by what's going on. Typically, you are responsible for whatever comes from your property. If it can be proven that the contaminants started at your property, that your property is the source, and it goes 1, 2, 3 properties over, the agency is going to look to you to remediate that, to investigate and remediate, sometimes chasing the plume for as far as it'll go. You might also argue that the other property owners are also responsible, but that becomes a legal question and a factual question.
Thank you. And then my question, if you're looking for a consultant to conduct phase 1 or phase 2 assessment, are there any particular qualifications or any suggestions about how to go about finding the right consultant?
Oh, that's a great question. I look for a company that has done this type of work before. And you want to make sure they have professional engineers that are doing the work, so they're certified to do the work. And usually you find a company that's done it, you can get referrals from them for other work that they've done in the past. But we should have a list, like a referral list, but we don't, I don't believe, Miles. So it's really about doing your diligence and finding the right company that's done many of these phase 1s in the past. And there's a lot of them out there.
Great, thank you. Well, audience, thank you for being so engaged. We got so many really interesting, thoughtful questions. So really appreciate your participation and attendance. As a reminder, as I stated at the beginning, the PowerPoint will be sent out to all who registered within a few days after this session. And then eventually both the recording and the PowerPoint materials will be posted to our website. And Kim, if you could go to the next slide one more time.
Not letting me go for some reason.
Oh, okay. Well, thank you again to, perfect. To both Heather and Kim for volunteering your time. Excellent, great content you shared and really useful hypotheticals. So thank you both very much, and feel free to reach out to Kim or Heather if you have any additional questions. And thanks again, everybody, and have a great rest of your week.
Thank you, Miles.
Miles.